Call the final case on this morning's docket, 117941, State of Kansas versus Crystal Dawn Galloway.
Good afternoon. May it please the court, Carol Longenecker-Schmidt, representing Crystal Galloway. Chief Justice Lucret, I would like 2 minutes for rebuttal.
2 minutes is granted.
Thank you. Unless your honors prefer otherwise, this morning I'd like to address the public trial issue, and if your honors would like to discuss jury nullification further, I'm also open to getting into that topic this morning. So the first question here with the public trial issue is, was the courtroom actually closed? There's two components to the trial that I argue were closed. The first one was the discussion of the jury's question about seeing the cell phone evidence. And I do think the state is correct that it is a bit unclear what exactly happened in the district court. Our argument is we're relying on the court reporter's note that left out the words.
What are you relying on that it was closed? I can't determine where it is that you assume that it's closed when typically the court is always open absent some sort of declaration. We're clearing the courthouse, it is closed, or courtroom, it's closed. Where are you getting that this was a closed proceeding?
I have three responses to that. First, the transcript notates open court throughout, except in this situation, it does not say open court. And I'm assuming that that was not just a mistake. But let's say it was a mistake. Courtroom closures can be mistakes, can be inadvertent. You lock the courtroom perhaps in between proceedings.
You have no evidence of that, though.
I do. That is correct, Your Honor. So my third and probably my best argument for that is, even if this court finds like the record's insufficient to say that the courtroom was actually closed during the conversation, I think the record is sufficient to show that the answer, the written response to the jury that went back to the jury room, there is no record of that when that was delivered to the jury. That was not in open court. So I'm basically arguing that the delivery of the judge's response, the judge's communication, and I would say the judge's instruction to the jury was not final until it went back to the jury room. Instructions are read to the jury. The court does not just write down instructions and then pass them off to the jurors. They read them in open court. And that was not done in this case. Now, I think there's...
Say that again. Are you talking about the jury instructions at the conclusion of the trial was not read in open court? Or are you talking about this specific answer to the question?
My argument is that the answer to the question, because this is a question about evidence and viewing evidence, the judge's response is akin to an instruction. It's a communication from the judge to the jury about evidence at trial. And I'm arguing that that's an instruction. At the very least, it's a communication about the substance or about evidence. And the Court of Appeals addressed this question a little bit in Womelsdorf. And the Court of Appeals, their reasoning for not making the delivery of the instruction or the delivery of the response public was that, the jury deliberations are never made public. Okay, that's the jury's private, contemplations that they're doing in the jury room. And if that's true, then why are we permitting a court official, a bailiff, to go into the jury room and kind of invade that private sphere without any record of what happens, of the ultimate communication, the delivery of the judge's response?
Doesn't this, even if you're right about all of this, you're arguing that this requires reversal, and isn't it subject to the constitutional harmless error standard?
I do not. My argument is no, that this is a structural error. I believe I cited, hopefully in my brief, I cited to State v. Cox, which was a public trial case from this court in 2013 or 2015. And in that opinion, this court said that you do not apply harmless error because of the purpose of the public trial idea It's impossible to apply. It's a structural error. It's impossible to apply harmless error to that. So, I think in a case like this, it's challenging because the facts and the crime are very, they're hard, they're severe. And so there's a tendency to try to compare the severity of the crime with what we perceive to be the error. But that's just not how the public trial analysis works, I believe, Your Honor.
What happened here, or what should have happened differently?
I think what should have happened, a couple things. One, inform the defendant of her Sixth Amendment right to a public trial and see if she wants to waive it. Two, the other thing, if she doesn't want to waive it, bring the jury in and communicate the judge's answer, response, instruction to the jury in open court. Or three, perhaps a compromise would be send the court reporter back with the bailiff. I don't know physically how hard it is to.
What happened with the bailiff
I don't know, and we don't know. That's part of the problem with these claims.
Was the answer to the jury question in writing?
Yes.
And you're saying we don't have that writing?
No, we have that writing.
We just don't have the record of what happened.
Right. We don't know. I don't know if the bailiff read it. I don't know if the bailiff just passed the note. I don't know if the jury had follow-up questions. But that's part of the problem with the closed record.
Is the fact that there's a statute that specifically contemplates this a problem for you? Are you suggesting the statute either doesn't apply or is unconstitutional?
I did not, because the statute says that the response can be in writing or in open court. I did not challenge that statute. I think to the extent that so I think a response can be in writing, but you just have to have some record of the delivery, the communication of that response to the jury. So for example, if the judge answers it in writing in accordance with the statute, and the bailiff, the court official, takes it back to the jury in their room, and then there's a record made with a court reporter there, then that would be part of the public record.
The record you want is just the bailiff
Yeah.
handed the note to the foreperson.
Yeah, well, I don't know. I want a record of whatever happened in the jury room when a court official went in there. Because the jury room, I'm not asking for the deliberations to be made public.
What if the bailiff slides under the door?
I would like a record of that.
So are any interactions between the bailiff and the jury fall into the same category? I mean, the bailiff is going to knock on the door to see if the jury wants to take a break to leave the jury room. Any of those, any kind of interaction needs to be recorded? Or?
I don't think so. I think this is significant because it's ultimately a communication from the judge through the bailiff to the jury. If a juror knocks on the door and says, "Bailiff, can I go to the bathroom?" That's not a question about the facts of the trial or the law of the trial or any way really relevant to the trial proceedings.
Well, isn't the point of the written answer that the bailiff's not going to discuss it with them? They just hand them the written answer.
Mm-hmm. I guess ideally, but we don't know because we don't have a record.
Our bailiffs usually take an oath not to
Sure.
discuss the case with the jury.
We
don't have any reason to believe here the bailiff violated that oath by saying, here's the answer, let me read it to you, let me spend some time explaining it to you.
Yeah.
We just have a written answer.
We're never going to be able, you're correct, Your Honor, I mean, bailiffs take oaths. We will never be able to answer your question because there's never a record. And because jurors don't have to talk to us, after proceedings. It's like an impossible, I agree, maybe most of the time it is to just slide the note, but we don't know. And that's the ultimate point at which the judge's information is communicated to the jury.
So functionally, what are you proposing here when there is a written response that all counsel, court, defendant agree on, handed to the bailiff to deliver to the jury?
Right.
Is the court reporter supposed to follow the bailiff?
Sure.
What is supposed to happen?
Yeah, court reporter could follow the bailiff. And yeah, it might be a simple, court reporter and bailiff enter the jury room. Bailiff passes the note to the, jurors and they exit. Maybe that's all that it is. Okay. But the fact remains that there's a piece missing here. And again, if we instruct the instructions that the judge gives to the jury on the law and the facts and what they can consider, that's always read in open court. So what's the difference? You can get into an argument about substance.
Well, hold on. I mean, the piece that's missing here is factual, right?
Right.
And there was no objection made. Mm-hmm. And so how is this even an issue for us? Because it's not just a question of law, because there are facts in question. If you'd objected, we'd know the answers to these questions.
Right. Well, again, if you look at Cox and maybe Sullivan, a case that came after from this court has said you don't have to object to raise a public trial violation, and there's no harmless error application. I apologize, Your Honor, I forget the second part of your question was about failure to object and insufficient facts.
Right.
I think, you're not going to have facts because there's no record.
And there's no record because there was no objection.
Exactly, but you don't have to object. This, I think also maybe in Cox, this court talked about do we remand it for the district court to make these findings about, was there a reasonable alternative to closure and apply the Waller factors? And this court said, no, that's not an appropriate remedy, because then you just have this kind of after the fact series of findings by the district court judge, and the temptation is going to be just to make it constitutional somehow.
And how do you get around Verser? It says you're subject to harmless error analysis, and so.
Because this is a structural error, and this court has stated that.
Verser says that's not right.
Verser says that public trial violation is not a structural error.
It says that this failure to answer a question in open court is subject to federal constitutional harmless error analysis.
Okay, well, I apologize. I don't. My understanding was that the defendant's right to be present, that is subject to a harmless error. You got to show that the defendant's, if the defendant wasn't there at all during the discussion, then that is something that you got to show, well, that mattered. But public trial is a completely different type of right, and it's structural.
Just saying, I thought we plowed this ground in Verser.
I apologize, Your Honor. I don't have any.
No.
Any other questions? Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. This court should do exactly what it did in Verser and other cases where it found the right to public trial was not sufficiently briefed, and also should find it's not preserved. An objection should be had here. Also, it's the state's contention that the passing of a note to a jury that was approved by counsel in the court is not part of the right to a public trial. As to whether or not the open court or the court was in fact open, it's the state's position, yes, the court was open. The court reporter in this case seemed to write open court only when the jury was in the room, and that's all they meant, but I don't think we should rely on the court reporter to tell us if a court was open or closed when there is absolutely no indication that the courtroom was ever locked. And in fact, the information immediately prior was that they wanted to move alternate jurors because people were coming in and out. There is just no evidence that this courtroom was ever closed. This issue should not be raised and is not sufficiently briefed.
Can I move you over to the sentencing issue? Because
Sure.
I think we spent more time on the one than we needed to. Seems like the judge wasn't going to consider something that the judge is required as a matter of law to consider. So why isn't that an abuse of discretion?
I think the judge erred in when he thought that he interpreted the argument to not be a valid mitigating factor, because by statute it is a valid mitigating factor. It's our position that error is harmless, that based on what the judge said after that, that even if the lack of criminal history would not have made the imposition be.
How do we know that, though? I mean, if the judge says, I can't consider prior criminal history or the lack of prior criminal history in my consideration and mitigation, didn't even consider it. So how do we know what the judge would have done?
Well, I think the judge then went through lengthy reasons as to why this Miss Galloway deserved the exact sentence she got, the hard 50. he went into great detail about the crime, and I don't think the fact that her criminal history would have altered that. If this court disagrees, then a remand is appropriate.
Would you have, we might talk about this when we get there, but I guess I want your input on this. Is this one of those cases where when we remand, we should direct it go to a different judge for
I
sentencing?
don't believe this judge is still sitting in that county, so you don't have to have that order here.
Well, if we were to assume that the judge might appear as a retired judge, which can be done by designation, that's at least a theoretical possibility. So I think the question's a fair question.
Okay, I hadn't considered that possibility. So I don't think that the judge so egregiously erred. No one pointed out to the judge that this was indeed a mitigating factor. No one cited the statute. I think the judge just made a mistake, and I don't know of any reason why this should be required to be sent to a different judge. I'd be happy to answer any questions you have on any of the issues, but otherwise I would just ask that the conviction be affirmed and preferably the sentence be affirmed as well.
Any other questions? Thank you, counsel.
Thank you.
Yes, unless your honors wish to discuss any other issues, I'm willing to waive my rebuttal.
Are there any questions? Okay, thank you, counsel. The court will take this matter under advisement, and